when he comes in, I'll kick it off. I'll give us an introduction of what we're going to do and what we're going to talk about, and then open the floor up, basically.
Excellent.
So there he is.
There he is. There's your hat.
Hello, mate.
Oh,
How's it
hello.
going?
We got lots of
Good.
Australians in the house today.
Yeah. Okay, good. So I'll start off, and I'll say, just want to thank, first of all, Jody and Darren for shining the light onto this insanity we're in right now. Much love to you guys, and it's bringing people together from all sorts of different backgrounds and different groups, and here we are collaborating, try to come up with a remedy, which you've already spelled out for us, but more dedicated to the Australian remedy, and then from there it's going to explode elsewhere. So first of all, thanks for you guys for sharing this light, and then thanks for everyone else to being open to this new knowledge and this new information, and coming into this meeting of the mind, so we can get to a spear and push this thing as fast and as far as we can. So that's the intent of getting one here. So first of all, I just want to thank everyone once again. And then basically, I want this Zoom to kind of go forward, and I want Darren to give us a quick little rundown of what they've done and where they're at, and especially with more of intent on behind the steps and the documents and the intent behind the documents, so we can really understand the purpose of these, of these little pieces of paper, which are so powerful, and then get you guys to basically summarize your process on your end and where we're at on your end. And then basically from there, I'm going to open the floor to questions from all these amazing minds around here, and just to, get some information flowing basically. So I will pass it over to you guys to kick that off.
Absolutely. Thank you very much, James, for putting these wonderful individuals together. As you guys know, we are very open to collaborating with people that are in this kind of industry, in this line of work, into this form of knowledge. It is very important to us to help you guys understand that we are about collaborating. We're not about reviewing old agendas, old material that's not working. We did have quite a bit of feedback from our last Zoom that we just posted. So we wanted to just kind of set our intentions a little bit before we started sharing our documents and these kinds of things. On our previous Zooms, we had people share with us what they felt needed to be changed or what have you. The confusion came when we were not clarifying that we weren't going to be adding this to our system. So for future reference, if something comes up that is a recommendation, which we are, like we said, we're more than welcome to hear it, to comprehend the information, get more knowledge on it, but we will be making it a lot more clear, because a lot of people thought, oh my goodness, we have to add all these new forms now. No, we don't. This is our system of equity. This is the way we're going to be proceeding. It is working. We are so thankful for the people that came and gave us knowledge, but please understand, we are not so much about the common law. We are more about equity, and we want to make that very clear. We are about involving it, and we do have high respect for it, but Darren's going to shed a little bit more light on that before we get into our forms, and I'll pass the mic here.
Sure. So over the course, as you all know, the last 10-15 years has been an incredible journey. We were all led to believe that all the answers lay in the common law. In the beginning here, we actually didn't really even know much about equity and what it was in its entirety. So it wasn't until we started really jumping in and discovering what the term merger means. And that's where we were really led to a new path where merger doesn't occur at common law alone. And essentially that's what we're trying to do here in the background. When two titles merge in the same person, an event happens. And as long as that person conveys one of those titles away, that's what creates the trust. And consequently, at law or the common law does not provide for this remedy. It will not, once we've volunteered or applied to use a identifying person to proceed into the commercial realm under our liability, we then came to realize, okay, hey, that was the mistake we made. And now in order to correct that, this merger had to take place. And a merger cannot, as I just mentioned, a merger cannot take place in common law or at common law alone. It actually needs equity to come in and support it. So here's where the dilemma happened. How do we bring the equitable jurisdiction in? How do we get it to assist kind of what the common law is doing for us. And here's why we needed it to assist: because we were deemed to be debtors, because we volunteered to be the liable party. That put us into a position where we're now, as you know, we're under the acts and statutes. There's no way to get out of it. Even if we were to bring exclusive equity in to deal with getting out of the common law, it didn't work. We tried it a number of times. It didn't quite provide the remedies that we were after. Then we discovered, okay, so hey, there's a certain number of codes or legalese type statutes and phraseology here that are literally dripping with equitable remedy and equitable jurisprudence. We just didn't quite have the eyes for it, way back when we first started. So now that we're doing what we're doing, we have now come to appreciate, as Chancellor Gibson here, I have Gibson Suits and Chancery. It's one of my favorite go-to manuals here. He provides 35 reasons why the common law is deficient. And we can go into that in a little bit here as to what some of these 35 are and why this is where all the equity is hiding, is in the 35 principles that aren't really recognized at law anymore. There are a couple, an abatement is one of them. A mandamus is one of them. A habeas corpus will work if you perfect your security interests and come at it with that approach. This is, again, the fundamental point that we missed. Until we get our hands nice and clean, until we do something with that birth certificate, until we complete it in some regard or some fashion, we actually weren't even really entitled to use the equitable doctrines. Why? Because it's still deemed that we are debtors, we are insolvent, we are notwithstanding, we are lunatics, enemies, belligerents, wards, the list goes on. So how does an infant even use equitable doctrines to, for a lack of a better term, save themselves? They can't. They literally have to do something in the background here to put them into a position where they can now go ahead and use some of these incredible doctrines and remedies that are available to us. And once we have done that, which is what we're actually effectually considering now, all these new doors open up and the remedies are right there laying at our feet. We just literally got to pick them up, walk into a court of competent jurisdiction and just say, hey, Your Honor, I require an order declaratory of the rights of the parties. And as soon as that is produced or issued, now you can take that single order, go back in and do all kinds of fun stuff. But until you get that declaratory order saying that you have priority, a superior, or an equal right to something else, we're literally stuck. We can't do a whole lot. And I know Kaz was mentioning there the other day that a colleague of hers has used an exclusively ecclesiastical type approach to get to where that lady or gentleman had aspired to get to. So that is one option as well. However, I'm suggesting here that there is enough remedy. All these common law people, all these loved ones that have been studying this for so long, we're not actually asking anybody to abandon that type of direction. No, all we're just saying is, hey, pay attention or notice this, and this is where we want to start injecting or inserting the equity. And that opens up a whole new realm for people that are very learned, very disciplined, very, versed, very competent with the common law. And again, Dean and I are some of the ones that, we were in the very beginning stages of all this. And I'm sure everyone here knows who my brother is. So it was only after 10 or 15 years of banging our heads against the wall that we were finally coming to the understanding, hey, this should be a lot easier than this. No one should have to spend 10 or 15 years to go through this. And as we're suggesting here, nobody does. So we're going to take a collaboration of all of our efforts, all these great minds working together, stitching together finally a component or a practice or a procedure that really gets us to the finish line, or at the very least puts us into a position where that individual can now just go to court, get that judge to endorse and approve the things we're doing. Because once the court approves it, now it's very registerable at the property registry. And again, the registration isn't quite going to be what we're doing. It's lodging or recording. And we know that's all coming down the pipe. So we'll talk about all that. And to introduce what the forms were, the phase one of what we're trying to convey to yourselves for your consumption is the adverse claim, the special affidavit in support of that adverse claim, and then really the evidence of perfecting that interest. And we're following it up with a security agreement. So the process here is simply this. As soon as we make an adverse claim, what is an adverse claim? Well, I have it right here. And
you guys should see his table and all of his law books.
Yeah, I know
to the left here. Yeah, he has to reach his whole body length to get at some of them.
I know there's everyone here is very familiar. We all got 5 feet of paperwork that we're dealing with at any given time. But an adverse claim, I just had it here for a second. You know what I'll do? I'll just go to, before that, I'm going to go to the plaintiff. What is the plaintiff? So here's the significance of us now coming as the plaintiff versus coming as the defendant. Here's what a plaintiff is. A plaintiff means a person attempting to recover on a security certificate in a legal proceeding. Huge. What is an adverse claim? An adverse claim is a party who's expressing an interest in a financial asset. What is the financial asset? The financial asset is the birth certificate once it's been converted, or once it's been completed, or once it's been endorsed, or once it's been assigned, or once it's put into the possession of that other party, like I keep talking about. That constitutes the adverse claim in itself. And again, the adverse claim is a claim related to a specific interest in a financial asset. The asset is right in our pocket. Once we perfect it, boom, that's the bulk of our problems solved right there. Now we come forward as the plaintiff seeking to recover on a certificated security in a legal proceeding. Again, now we'll just be loosey-goosey with the word legal proceeding, because we're actually going to be trying to get into equitable chambers or judges' chambers, which again, they're not going to really publicly disclose that in all these acts and statutes. You know, they're not going to quite word it so that it's very easily interpreted and then moved on. So as we know, there are a lot of layers here. There are a lot of misnomers and misinformation and disinformation out there. But again, two critical components: the adverse claim and coming as plaintiff. That's 2 out of the 3 that we really need to do. Now, the trust expression or the security agreement is literally just going to kind of give the judge a little bit of meat and potatoes to play with, to see if we kind of know how to play the shell game, moving these titles around, how to assign that interest. Once you've assigned that interest as the assignor, you are entitled to the performance of an obligation owed to you or us now by the new trustees. This court process, the declaratory order of rights of the parties, that's the beginning phases of putting the legal interest into the transferee. The 100% security interest or legal title gets switched, or it gets moved to the custody of a whole other person. Well, that whole other person happens to be, from my experience, is the successor in interest, who behind closed doors is the custodian of enemy property under the guise of a mortgage taken away from us in 1930, whatever, under the Emergency War Powers Act and the Emergency Banking Relief Act, which again is a global consensus that they passed throughout. After that mortgage takes place, we are deemed to be the debtors, and we're deemed to be liable to pay this mortgage really for the rest of our lives, until we come forward and correct all of these mistakes. So that kind of leads into what the whole purpose of the adverse claim was. It is literally that little blurb on the security certificate itself in registered form. That's the condensed version. I didn't feel like it was adequate enough, which is why I created the other security agreement. That other security agreement, depending on which region we developed it for, some of them are 2.5, some of them are 4 pages long. I just got to a point where just lay a whole bunch of substance down, and as the judge is flipping through it, if there's anything in there that's not appropriate, he can stroke it out, he can reform it, he can rip up my stuff, our stuff, and just recreate the whole thing. Point is, I wanted to come in with a little extra substance rather than a little less substance. Let the paperwork do the bulk of the talking. And as we know, chancery documents or equitable pleadings are the paperwork. It's not a courtroom that says, hey, equity courtroom 105. Yeah, no, that's not how this works. We spent years, and I'm sure some of you did as well. Hey, clerk, where's the chancery court? And they're looking at us like we got 4 heads. I'm like, get out of here, you lunatic. You don't know what you're talking about. Which is all part and parcel to then keeping this stuff quiet. Why? Right after that mortgage in the 1930 whatevers, 33 to 39, right after they passed all that legislation, then they went and passed the Secrecy Acts. And the Secrecy Acts apply to all of those agents that says, hey, you can't talk about anything that just happened or just transpired. All you can really do to provide assistance to a complainant is, well, you better get some legal advice. So that's where we all jumped into the common law, and we're all looking at all this common law stuff. But you know what, guys? After 15 to 20 years, we weren't satisfied with the remedies we were achieving exclusively using the common law, which led us to go looking for equity. And then we tried the equity by itself. That didn't quite produce the results we were looking for either. And then it wasn't until then that we actually merged the two. And this is what the Judicature Acts 1873 to 75 actually provide for us. Generally in all matters where there's a conflict between the rules of equity and the rules of law with reference to the same subject matter, the rules of equity shall prevail. Huge, but they took the Chancery Court and the common law courts and made them one court. So if the judge is seeing that you're walking into public court, answering to that public name, using the surname incorrectly, assuming all the liability, he knows that you just waived your right to the equitable defenses. And here's the other dynamite part about rolling into court to defeat that presumption. The court of itself will not presume a party to have a better title or better claims for equity than the pleadings of the party himself disclose. Here's the other one. It is presumed by the court that you understand the law and you know what equity is. Problem is, none of us actually knew what equity was. So now we're all subject to the rules of the common law, and we're all just getting, and we're like, what's going on? We had no idea. There's no recourse, no remedy, no nothing, because it was presumed that we knew what equity was, and we're just not choosing to exercise those options to our own peril. Oopsie doops. And again, it's not up to the judges to say, Mr. and Mrs. Johnson, you may want to exercise some equitable doctrines here to preclude you from going to jail for 25 years. As a matter of fact, here's a cool story. We had this other colleague of Dean and I who lives in the United States, and he does some incredible equitable work. And some of you may even know who I'm talking about, although I'm not going to mention his name on public airwaves as he's asked me not to. He had a student that walked into public court, and because she provided a couple little equitable defenses, if you will, when the judge, this was at sentencing, this woman was looking at 20 years. I don't know what she did. I don't know. I never even found out what she did. But after she tendered a submission, which was just a few equitable defenses, and the judge says to her, you are hereby sentenced to 20 years and blah, 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 blah. She stands up and says, Your Honor, with all due respects, I do not accept. I do not accept. I do not accept. The judge is looking at her like, rah, 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 rah. He says it again. You are hereby sentenced to 20 years to blah, 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 blah. And she did it again. I don't accept. I don't accept. I don't accept. Then counsel, approach the bench. So the judge calls both of them up to the bench. It's all whispers and quiet at this point. And the judge says to her, would 15 years be more acceptable? She's, oh my God, no, of course not. I do not accept. I do not accept. I do. Well, then you are free to go. How do you roll into court on sentencing day facing 20 years in the can and walk out in 5 minutes with a decision like that? So I know we're all going to be tested. We're all going to be put through the grinder I'm thinking everybody on here, except for maybe Kim. I don't think Kim's been to court and was facing criminal charges like the rest of us have, but she gets to share in all of our experiences and
deemed dead.
Or yeah, all that kind of stuff. So again, the plaintiff here recovering on a certificated security. We know what the certificated security and registered form is. Y'all got it in your purse, your wallet, your bank, safety deposit box, whatever. But it's sitting there incomplete is what's creating an environment or putting us in a position where we are stuck as being the debtor, being liable, being the party to service this debt for the rest of our life. So adverse claim, part of phase one, very important. The affidavit in support thereof, very important. And we know what the purposes of the affidavit are. We're attaching other documents to a piece of paper or an instrument, just so the judge can. It's just more of an organizational type thing. And as we do know from most of my experiences, an affidavit is just an affirmation before King David from 2,500 years ago or whenever that happened. Again, pretty important stuff. Swear and affirm on the affidavit. Yeah, there's a lot of conjecture on that stuff. A lot of, well, the Bible says to not swear on anything. And yeah, that's all good. You can literally affirm. That's going to be, pretty much as resolute.
The other thing I want to talk about as far as step one, just to kind of clarify, just for some of our loved ones that had a lot of questions around this, when it comes to those documents and where we are with that, Kim has made them in edible and fillable format. We are not particular on the kind of paper. We do insist that a red border goes around the adverse claim. Do you want to explain quickly why that is?
Yeah, as most of you guys know, the border just prevents any public interest from infiltrating our paperwork. Literally, you're building a wall around your castle. That's essentially all it's really doing. Keeping your stuff private, keeping the public out. There are other spins on that, of course, but as in a nutshell, that's essentially what it's doing for us. So
we also don't believe there's a huge what's the word I'm looking for? Relevance to the type of font or the type of paper that it's printed on, and perhaps you can explain that a little bit.
okay, so we're deemed to be debtors. We're deemed to be in a realm. We're deemed to be stuck. So we're of the opinion, hey, if I'm in a particular world, speaking a particular language that they understand to help my ass get out of this particular situation is actually not a bad idea. We've actually sent in tons of material where, again, using exclusive equity, the courts are just spitting it back saying, you know, we don't recognize this and we can't acknowledge that. And there's no process at law, blah, 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 blah. Again, which is perfect though, because that's the judge handing you your remedy on the silver platter. Hey, if this jurisdiction can't hear your equitable pleadings, you might want to do something about changing the jurisdiction, which you do when you come forward as the plaintiff. Now, equity regards substance over form. Yes, I know people have had success using the robin's egg blue paperwork and not using the Roman font as Zev was mentioning the other day. But I'm kind of looking at it like this: I want to get effectually conveyed as efficiently as possible my modes of the remedy I'm seeking. So I'm actually going to give it to them in the exact format that they can understand it and that they can act on it. I don't really want to present them something that they're like, this is foreign to us. We can't help you because we don't understand it. So this is, again, where we're using a little bit of statutes and acts and codes, legislation, if you will, to get ourselves into a position where then after the court appearance and the settlement, now we can live in the exclusive equity world. Now we never need to touch a legalese word ever again. Why? Because your new trustees are going to do that for you, who at the end of the day here become the new registered owner. The new registered owner is the one who's liable. Principal debtor. We are secondarily liable, and that comes through, again, once we get the contribution on subrogation, which means we're paying that silver coin, that's the contribution. Hey, I'm paying somebody else's debt, or I'm putting this debt configuration into a new relationship. That silver coin by itself is doing some incredible things for us in the background. Once we have ourselves in a new position, we are now subject to being exonerated. Hey, Your Honor, if the creditor does not bring suit against the principal debtor within 30 days, the surety is exonerated. Ta-da! How slick is that? It's not up to me to determine whether the creditor seeks payment from the principal debtor. That's up to them. I really don't give a shit. That's their doings. However, my claim or my process does not fail or does not become fatal only because they're not exercising their option to recuperate or, be compensated from that debt obligation now. And if they choose not to, I don't care. I'm still exonerated. Subrogation on contribution equals exoneration. Wow. They don't offer that at law. Again, another equitable defense, but you can't get into chambers. You can't get that equitable defenses in your adverse claim before a judge publicly. It's a lot harder. We're better off just making proper adverse claim, bringing a suit at chambers through an application. Get your application or your notice of civil claim first. Once that's filed at the court, which we've done under the chancery listings, now create a petition. The petition can be done without notice. The petition is very powerful. It's saying, hey, you can even do the petition without a hearing. The registrar or the judge will literally just look at your petition and make issue process, get it before a judge, do all kinds of stuff for you right there on the spot. If you can show, hey, I've settled something, I've done something, I've produced some information, or I've conveyed an interest to the personal property security registry or land titles, and look at my output, Your Honor. This right here on the face of the instrument is suggesting that there's a new debtor in town and it's not me. Oh, well, what have you got there? Well, Your Honor, we had a confusion of titles and I've done this, and I'm just hoping that you may complete the 100% legal title in the transferee. The transferee is the receiving party, the party who has just welcomed all the debt and liability. Because again, remember, the state doesn't want houses, cars, boats, and planes. They want the paperwork that's attached to all that property, because that's all they technically deal with. So both parties are happy at the end of the day. And again, here's something that the at law or the common law just simply does not provide. And again, as we get a little bit into this, I will literally go over the 35 reasons why the common law is deficient compared to equity. So
on that note, real quick here, just to get back to that, we are certainly not saying that what Kaz and Zev are doing is wrong, but
Oh, yeah,
by no
no.
means. If you want to put it on fancy paper and use certain font, go for it. We don't
Yeah.
care. We just don't feel it's necessary. That's all. Okay, just to give clarification, but we absolutely 100%
And
support our loved ones who do.
yeah, and again, my brother literally from solitary confinement. This was part of his 90-day stretch. He was literally in solitary for 90 days. He set the Canadian record. Nobody in Canada has even come close to that number. So anyway, he's sitting in solitary. He's literally writing on a paper towel with crayons. He got that before the judge, and he was released 4 hours later. So if you can write in crayons in a paper towel, it seems to be effective. And once you get in front of the judge, you can literally just espouse all this by word. You don't even have to have anything written down. I could literally, by viva voce or parole evidence, I could literally speak to the fact, hey, Your Honor, it is the desire of the settlor herein to convey and assign 100% security interest to the new debtors. Name the party, right? The successor in interest. Here's his address for the purposes of settlement of the estate. That right there, that simple blurb right there, nothing in paper, but here's where it gets a little sticky. When you start doing land transfers or interests that are attached to land, and we know what land is, it's not just dirt. Land means a whole bunch of stuff. Those deeds must be in writing. Very important. And when it comes to time to lodge our interests or record these paper events, me saying it vocally kind of doesn't quite get the job done. Could I actually require of the judge at that point, here, I just said it, you go ahead, you write it all down? Yeah, that would probably work. But at some point, the viva voce or the parole evidence, the word of God, if you will, it gets you so far, but then someone's going to have to start putting this stuff down in writing. I mean, that's just consequently the way this commercial system operates. And I don't really see a way, I don't even see a reason to try to get around doing it in paper. I mean, I'm just throwing this one out there because on Facebook, and for example, I've had a number of loved ones coming back at me with, oh, screw your entire paperwork. I'm a man living flesh and blood, and I just rolled into court and I just spoke it all. Well, that's possible, but you better be of a certain level of competence or a certain level of wisdom and comprehension to pull that off. What I was suggesting there was, hey, look at our paperwork, use our paperwork to get you before a judge. Once you're before the judge, now you get to go back to you and you get to tell the judge what the rest of your life looks like. Getting that entered into the minute book requires a written deed, a duly sealed or a duly executed, a duly delivered instrument. Puts the judge into a favorable position where he can really help you. So yeah, either be really good at using the voice or just show up with some simple paperwork and say, hey, here's where we're at. And if I'm deficient in any matter, equity is going to come to my rescue because equity will not allow a trust to fail for want of trustee. And as I've mentioned several times now, from what I'm experiencing, that trust arises the moment we endorse that certificate of security and the moment we stick the valuable consideration on it and the moment we assign that interest to a new party, boom, that's a trust right there. That's an express trust. They actually call it in all these books and pages of legislation that I'm looking at, they refer to that as a security agreement. So the security agreement is literally just going on to say, hey, once this transaction has happened, this is what's expected of the trustees. Now, this is why all these acts and statutes now apply to the Crown, or the Crown is bound by these acts and statutes. The new trustees now actually have to follow all this legislation. So once the new trustees have their hands on that, and again, this is just telling the judge, hey, we sort of know what's going on here. I do expect specific performance. I do expect an accounting. I do expect an injunction. Temporary to get the ball rolling, but then we actually have to come back and require the permanent or the perpetual injunction, which is something I haven't talked about yet. So there's actually two phases to the injunction, but just throwing one out there. The recovery on the certificate is critical because if the signatures are admitted, which means two, our birth certificates only come with one. So as soon as it's saying signatures, again, we're talking plural, that's us completing this component of the transfer. And as soon as the judge or the registrar or the clerk sees that information, our world just changed. So we've actually used, again, a little bit of the common law to get out of the common law, because we're still trying to use a language that they understand. Well, shit, they're the ones that wrote it. So of course they understand it. Use a little bit of that to better our position. Once our position's bettered and we're brought before the court, now we can switch to exclusive after the fact and just mop the floor with everything that needs to be done. I also require the appointment of a personal representative. The appointment of a receiver manager. The receiver manager is the secured party. They're the ones receiving a special interest. What are they going to do with that special interest? Well, according to the security agreement, this is what you're going to do. Boom, 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 boom. And I've actually laid out that security agreement in relatively chronological order, where I'm not asking for specific performance up front before I've actually even put them in possession of the interest. Like there's a chronological order that I did spend some time on it. Could I whittle that down to one page? Yeah, absolutely. Again, as I've indicated earlier, I do way too much than what's required, because I would rather have the judge or the clerk or the registrar, flipping through a few pages, and they just kind of go like, well, it certainly looks like this. There's some substance here. And again, these people, they know what they're doing. They speed read. A lot of them are ex officio postmasters. Like there's a lot of cool stuff going on in the background that we kind of take for granted, or we don't even really realize is there. What happens once you make the adverse claim? Once you suggest that is done or it's established, no other party globally can now roll in and attach an adverse claim to your adverse claim. Doesn't work. Off limits. It's like a firewall or an antivirus protection is literally around your estate now. No police officer, no vid enforcement, whatever they call them when you walk into Walmart. None of that stuff applies now. No one can attach liability to you because your adverse claim has priority. That, in effect, stops. It's called estoppel. It literally stops the secured party or any other variant thereof or agents to literally come after you for anything legal. You're literally plucked out of the legal system and you're dropped somewhere else. Safe. Nobody can deal with you at all. As a matter of fact, they run into the attorney general first. Why? Because the attorney general winds up being the administrator of your estate, your life estate. Again, estate on the public side is kind of half of what we're after. You actually have to put the life in front of it. And a life estate only exists in equity. It does not exist at law. So once the life is attached to the estate, that's a trust. That trust is now enforceable in equity. Like, I can go on for hours and pages talking about the enforcement under a bill in equity. Is essentially what we're trying to do here. The bill in equity is not even heard. It's not recognized at law. So use a little bit of at law to put us in a better position so that now we can roll in with our equitable stuff properly and just, have at it.
So that takes us to where we are with our forms, just to kind of help you guys understand where we are with that. I mentioned this last night, and I'll give you guys information about this as well. Starting tomorrow, we're going to be on a divergence blackout. We are not going to be answering any messages. We're not going to be getting back to no Zoom meetings. There's going to be no activity whatsoever on any of our pages. And we're doing this by design because we are getting stage 1 done, which is those 3 documents. That's going to be the adverse claim, the security agreement, as well as the affidavit. So that's going to be done for 3 provinces here in Canada, and we're also going to be doing it for you guys in New Zealand, which is super exciting. So Kim has worked on those documents. We're actually working with Anthony as well. He's compiling them for you guys in your area. Then Darren, of course, is going to give the approval on that, making sure everything's all tight and buttoned up. And then we'll be releasing it onto our Australian page, onto our Ontario page, our BC, as well as our Manitoba. And we'll be doing that on Monday. So that's what's going to be really exciting. We're going to be linking it to actual video tutorials. We do not want people just being able to click on our forms to be able to alter them or to be able to fill them out and submit these kind of documents without them understanding what they're doing. So we're going to be doing our due diligence where people have to listen to a tutorial, listen to the information. Then as they're filling out the fields, they're going to know exactly what it is that they're doing. Okay, so that's where we are right now for phase 1. Once we have that, then it's much easier for us to upload these onto our different groups that we have for these people to start converting them into their own legislation. Then they're going to upload it. We're going to prove it. This is where we're calling in our loved ones, calling in people who have experience and understand this kind of language to be able to compile these documents, to be able to put this together for us so that it literally just coming back and Darren's looking over it and approving it and boom, and it's released for that country, right? So So this is a wonderful collaboration that we're really excited about doing, but we realize we have to completely unplug ourselves from all of these messages and just the pounding that we're getting right now to be able to provide what it is that you guys are wanting from us, right? So yeah, I think if anything, people are going to be excited about it. We've left enough content and videos on there to keep you guys busy for the next 4 or 5 days while we do this with Kim and get this all rolling with our IT team.
Yeah.
So that's where we are for right now. So how about we open this up a little bit to any questions that you guys might have, because we've dealt with the first phase of this anyways. So if you do have a question, please just raise your hand and you can unmute yourself once we call your name. No questions. Look at that. Oh, okay. There we go. Go for it.
G'day, how's it going? Can you hear me?
Yeah, go ahead.
Okay, hey guys, hey everyone I know, and for everyone else, I'm Javen. Look, I thought I might just start with putting a tiny little pinprick into the balloon, because I wouldn't say in trouble, but I did some registrations and they all got taken down.
Yep.
So basically I rang the assistant of the deputy registrar for the PPSR and said, what's going on in relation to that? You know, we had a bit of a yarn. What I did was I actually said, okay, I threw this scenario without saying so much at her and said, look, this is actually what I'm going to be doing. I don't care so much about those registrations. Thanks for letting me know and giving me threats of fines and so on.
Yeah.
But moving forward, this scenario, does this relate? And she said it actually comes under, I can't remember the section off the top of my head. It is towards the court section, I think, of the PPSA in an Australian one. And it talks about where the laws or legislations relate, especially to land or something that might not be registerable on the PPSR, you would be using the legislation there for that state's land. So effectively, right, the Property Act for Victoria, the Real Property Act for New South Wales, and so on. So what she's indicating is like when we're talking about land, and I did explain that land doesn't mean soil, as we know. She said, yeah, I think we sort of know what we're talking about here, is that you would be specifically dealing with the state's legislation and those processes there in relation to land transfer, Settlements Act, Trustee Act, if you wanted to get into it, and so on. So I thought I might just sort of say she did mention that pretty much once you go down that road and you're dealing with that the PPSR or the PPSA is really no longer necessary to a degree. And that's something I thought maybe I'll just let everyone know that I have gotten a little bit of info on that.
I do concur with that. I was of the approach that, hey, I wanted to show up to court with something that shows the judge that A, we're relatively competent, we B, relatively know what's going on, and C, we relatively know what kind of remedy we're trying to pray for. I think that the biggest problem with the PPSR registries are when they ask who's the secured party, many people are putting the all caps name there as the secured party. We didn't. We actually put who's the secured party. I literally put the successor in interest. Who is the successor in interest? Well, in the financing change statement that comes down the pipe a little bit later, that's where you disclose who the successor in interest is. And consequently, Minister of Finance, custodian of NEB property, yada, yada, yada. The minister who's managing or administrating the escheated legal estate while it's still abandoned, that's the Minister of Finance. That's who we're suggesting, hey, you're the successor in interest. Now, again, Dean and I have been trying to effectually get something registered at the PPSR place for the better part of 3 years, 4 years. We were constantly getting rejected. And we couldn't really put our finger on it. We were doing a lot of this, but it wasn't until I found the successor in interest component. And then boom, we landed two interests at the PPSR within 30 seconds of themselves. Identifying who the secured party is properly, that seems to have made an incredible difference.
Yeah, I think the big issue that I wanted to sort of add on to that was that she said that transfer needs, obviously we're talking about a third party, so we need a secured party, we need to make one for ourselves. Then we have, you know, the interest and so on, and the grantors. So what we're doing is we're then moving that whole thing over to a new successor in interest and so on. And the transferee, the one receiving it, or the new secured party, actually, by our registration laws here, if they don't want it, then it can't be registered. So where they've basically put it down that the agreement, it needs to be accepted by whoever's going to be taking it. The only thing I can see that working when we start doing that, So the only way to really do it in Australian law would be we would create a secured party, and then we would transfer that interest over to a new secured party. It needs to be by an agreement. The problem is you would then have to take that to court to have that enforced by a court of competent jurisdiction to enforce that transfer. The other thing is that I sort of felt, it's kind of because you're using that law in relation to the transfer, but we're really mainly dealing with the land acts for each state. And that's why I feel as though I have expressed to some of the other guys here that it kind of feels like it's just the land and the land transfer stuff. I mean, it's all well and good. And I did ask her, can I quote the law from the PPSA in relation to a security interest that maybe is not registrable in your system? And she said, well, she didn't say yes or no. She said anything that relates to something unregistrable that's in the PPSA, yes. But she didn't want to give me advice. I said, no, I just want you to explain the law, and she wanted to end the conversation. So basically, I feel as though it's really just dealing with each state's law, because as I've searched through, I found everything that's in the PPSA. I have managed to find, I've dealt with Victoria specifically, basically I've been able to find everything that I need to quote those specific things that are in the transfers or the PPSA, etc. And many things you mentioned before in relation to the estates and so on can be found throughout those three: the settlement of property, or whatever it is, the Settlement of Land Act. You've got the Transfer of Land Act and the Property Law Act, all in there, comprise of everything that we really need. So I'm just putting that out there for everyone.
Yeah, for sure. The third party that you're just mentioning there, I established that to be the securities intermediaries. That's the third party that you're referring to right here. Now, the legislation in Canada refers to securities intermediaries like substantially. There's a lot of verbiage here on who the securities intermediaries are, what their duties and obligations look like once the possession has transferred hands. The securities intermediaries play an incredibly vital role, because you're right. The securities intermediaries, that third party, they're the ones that hold the certificate. The certificate actually does not go to the possession of the Minister of Finance or the successor in interest. No. They have access to it. They have, use of it on the legal side, but they don't actually have strict possession of the instrument. No, the securities intermediaries do. And I think that's just to keep everything fair and on the up and up in terms of trust doctrines. So that is an incredibly important component, and I do completely agree with what you're suggesting there. We were trying to act as the intermediaries and negotiate this thing by presenting it to ourselves and all this other, again, through trial and error, we've come to appreciate, hey, we kind of missed the boat on a few things there. But as a matter of fact, when we do our 4-day blackout here, that's a particular subject matter that I will address in depth as to who the securities intermediaries are. I'll go through all of this stuff, and I will this number, that number, this is why, that's why, all that congruent or all that concurrent stuff that actually has to meet in order to present our packages to the courts or to the registrar at land titles or the property registry effectually. We're experiencing the success with it now. And as soon as we rolled in to get our chancery listing motion or application filed, the clerk was kind of looking at us like, well, but as soon as we showed her that output from PPSR, her eyes went oink, oink when she read it, because as soon as she saw the secured party had changed, now they have to grant us entry into a chancery type setting to effectually settle all this stuff, because the at-law common law wasn't quite capable of dealing with it all properly. So incredible progress. We're getting there.
So solutions empowerment, bless you, you're so cute putting your hand up. If you go into dots, you go in your dots there, you can actually raise your hands. You don't have to physically do it, and then we'll get to you when we can. Because you were just so diligent, we'll take yours first, and Kaz will come right to you right after.
I think Darren just answered really the question I had, because I've avoided the PPSR for many years only because you couldn't record or register title of property. So, in 2003, I did the Uniform Commercial Code financing statement. It was my understanding since then that the title case format of your name, which is separate to the capitals, you are acting as secured party to recover the abandoned property. But from what you're saying is that status still hasn't got the ability to settle all kinds of claims. So you're really needing to transfer that position to someone that has the competence to do it.
Yeah, and as a matter of fact, we're not even really entitled to even transfer that thing until we assign it properly. Unless you do that endorsement on the certificate itself, that does not, if you skip that or you waive that part, you've actually brought no evidence before a judge to say I'm even entitled to transfer this thing. So it's a very slick kind of way. It's a little bit slippery how the Jesuits presented it to us and said, no. You got to complete that certificate first to open the door for us to even be able to record it for you. If you just come at us with nothing, they actually can't really help us a whole lot. And again, after banging our heads against the wall for 10 years, we're finally coming into a situation where we're finally able to appreciate some of these variables. So, yeah.
Excellent.
Now I'm understanding why there are many claims from all over the world saying that by you asserting that title of secured party is not completing the actual transfer.
Yes.
But no one could ever explain why it was deficient.
Yeah, it's like you're trying to express a trust with yourself. It's like it requires a little bit more depth than that. And again, until we can actually identify who the true parties in interest really are, we were at a bit of a loss. We just used to walk into court. Oh, I'm a man. None of these acts and statutes apply to me. And the judge says, oh yeah, well then you're going to jail for 3 months. So
Yeah,
it kind of
the problem with that is people are asserting things and making an unsubstantiated claim.
Bingo.
I don't actually do that. I ask, is there anybody in this courtroom who claims that I am not a man or a private man? And when no one speaks up, that you have an agreement by assent that you are in that position, and then you win.
Sure.
We've got to stop claiming things that we can't substantiate.
Yep. Agreed.
That's equity too.
Yeah, and again, as soon as that adverse claim is literally right on the birth certificate, that little red paragraph diagonally that I think I've posted a number of times there, that in itself kind of constitutes a mini security agreement. But to me, it just wasn't in depth enough. I was like, no, I want more. I want to talk about the obligations and the performance owed to the secured, to the beneficiary through the settlor. I just got a little bit excited with it and just let it rip, because I didn't want to get to a point where I was in chambers and the judges are going to say, okay, well, you missed this, you missed this, you missed this, and you missed this. What do you want me to do? And I just didn't want to be put on the spot and I didn't want to drop the ball, maybe call that fear-based, but I was the type of individual that, no, I'd rather go in with too much and let them sift through the too much and identify what was the critical components. So yeah, here we go.
No, good. Very good.
Excellent. Thank you. Okay, Kaz.
Yeah, hi. So when we did our PPSR, one of the requirements under the PPSR regulations and rules is to notify the appropriate parties. So what we did was we actually wrote a letter to the Minister of Finance and notified him of our standing, which included our PPSR number.
Nice.
Yeah, so basically I think that's part of the reason why we're seeing what we're seeing, as far as even if we get pulled up now, they're not even willing to deal with us anymore.
That's right, yeah.
The only thing that the part that we have missed, and I actually said this to my team about a week or so ago, is I think they're just waiting for us to hand over our birth certificates.
Yes.
So that's the part that we're in the process now. We have actually found the legislation for Australia and New Zealand, because there's two teams.
Beautiful.
For the adverse claim.
Yep.
So that's the process that we wanted to do. The question I do have is that when we did our PPSR, we wrote up our security agreements. We've done our hold harmless. We did our claim of right, intent, and statement of truth. We did our common law copyrights. We did the whole lot, and we included all of that into our PPSR as well. But we made ourselves as the debtor as our caps and our creditor as our lowercase first names. That's based on our birth certificates.
Sure. Yeah.
So as I was saying to you yesterday, the PPSA registrar has removed a couple of our sovereigns because
Gotcha.
they're saying you can't have a contract with yourself. So they're
Yourself.
calling us fictitious and fallacious.
And
But we also managed to find all our QSIP numbers for
Okay.
all our so that part of is part of our argument. Well, in actual fact, that is just a mortgage that you're trading on. Here are the QSIP numbers.
yes,
We are actually, living beings with just a first name.
that's right. Yeah.
But now you're saying we should change it to the successor.
Yeah, because I'll be honest with you, Kaz, as soon as I did that, boom, they accepted it. And then when we presented it to the courthouse to get our chancery listing, they accepted it. So I'm like, well, that's 2 for 2.
Right.
I don't think we would have gotten.
I think the problem was that the 2 people that had been removed or being removed at the moment had never sent the letter off to the finance minister.
Okay, yeah.
The rest of us had done it. You have to do it when you register your PPSA. You actually have 15 days to notify the minister that there is a PPSA in existence. If you're changing them into there as the secured party, you only have 5 days to notify them. But you notify them. You don't send them all your information, is what you're confirming as well, because we didn't either. We just sent the PPSR number, and that we've, under the legislation, we are now secured. We are now have an interest in our estate.
Sure. Yeah, absolutely. Yeah, completely agree with you. And again, if you're not able to create a contract between yourself or between ourselves, then we're certainly not entitled to create a trust between ourselves. The concept of a trust is, hey, I got something and you got something. And that's where the agreement says, well, then if you gave me this of value, then I'm going to owe you something. And here's what you owe me. And that's what we wrote out in the security agreement. This is what you owe me. 4 pages of stuff.
Yeah. We also wrote a bill of exchange.
Yep,
So
okay.
I kind of think that what we actually did was we went around it a bit differently to what you did, because we placed a value on ourselves within our security agreement, and then we actually made a bill of exchange for that amount from the debtor to the creditor, so that there was a fictitious. But we added their fiat money, but we also added silver and gold in that bill of exchange. Yeah.
And this is where the minister has the power to convert securities to money and money to securities. So having the minister involved in all this stuff is incredibly important. As a matter of fact, we are bringing in the Attorney General and the Minister of Finance in our petition to say, hey, you were noticed of these things, and now here you are in court, or your representative is in court, and this is where the judge is now able to assign these debts and obligations to the new party sitting right there, and they can't get out of it. There's no wiggle room for them. That's it. This is the transaction being completed, and wow, are we ever glad that we're here where we are at this particular point in time, given what's going on in the world.
Okay. Did that answer your questions there, Kaz? Perfect. Okay, so now I think what James was wanting us to do is to go over phase 2 now.
So phase 2 is essentially this. When we get into chambers, the judge is going to say, okay, so how does this end? How do you want me to help you? Well, Your Honor, please approve my deed absolute declared to be a mortgage in equity. Please notice and acknowledge the caveat thereby to cover that mortgage, special mortgage. And here's the declaration to support those other 2. Essentially, that's phase 2. And I'm of the opinion, like, let's just get into chambers, and then we'll throw phase 2 at the judge right then and there, or, include it in the documents as the exhibits to get it before the judge so that he can actually look at what we're trying to do. Because again, we've actually had firsthand experiences where the judge is like, okay, anything else? What do you want to do? What's the direction here? And back then we're like, as soon as you start scratching your head, the judge knows you're not ready and you get booted. So, it's important that we understand what the phase 2 is. And because this was deemed to be a mortgage back in the 1930s, as I was suggesting to Kaz and Zev here yesterday, once that mortgage is established, now we just convert the mortgage because it's already existing. It's already there. Well, we just have to claim or adversely claim our proper interest in it. And that's all we needed to do. Hey, Your Honor, what do you think? Will you decree these events? Will you order that the security now vests in the new trustees. Again, vesting is a huge component of what we're trying to do. We were deemed to be vested with the legal interest at birth. Why? Because it was abandoned. It's pretty simple. When we cure the abandonment, or when we cure the escheated estate, that puts us in the position to say, hey, Your Honor, look what I did, look what I did. And they have to say, yeah, okay, you're right, we agree, we agree. There's nothing that the judge can say, because the judge literally looks around and says, well, I don't see another man or woman here that can rebut your claim. Therefore, I'm compelled to process and issue you your order, because no one can rebut it. It's freaking impossible, especially when the attorney general or the deputy attorney general is sitting right there, and the minister of finance is also sitting right there, and they have to be quiet. They can't chirp, they can't say a peep, because you as the plaintiff brought the equitable jurisdictions into that hearing, and these public characters have no voice. They only have to sit there and take their lumps. And, taking their lumps is actually very beneficial to them in the background. They get the 10% of our estates, and they're very happy as well. So it all works.
So what forms is stage 2 then?
So stage 2 will
Which
be,
forms?
so that'll be the actual mortgage. I have that completed for Manitoba. I have it just about completed for British Columbia. And again, the mortgages are all pretty simple. I mean, we're actually creating a value, as Kaz was just suggesting. We actually establish and attach a value that we think is appropriate. Once they have that, they balance that against their mortuary tables, respecting trusts. Believe it or not, the older we get, the less our estates are worth. Their maximum value is when we are about 14 years old. That's the maximum value. So as you get older, the system is kind of looking at it like, well, you've only got 5 years to live, so you probably don't need access to trillions of dollars in credit. So our mortuary tables actually declined or descend as we get older. That's right in Gibson's book here. So it's a thing. All these tables and all these calculations, they're all pre-done for us. But they wanted us to establish a value first, and then they will confer that or approve it or adjust it or whatever. But again, it's like we're presenting what we deem our own estates to be worth, because that's a power position. Again, if we had the power to waive all our rights at birth, we also have the power to enforce all these rights. And no man or woman can come before me and say, no, Darren, your estate can't be worth $1 trillion. My position is like, you are a man or woman notwithstanding. You don't have priority in this situation. I do. And when you take a look at the vast wealth out there, $1 trillion is literally a drip in the bucket. It literally is. On the equitable side, if you guys want to check out Walter Burian in the United States, when he's talking about the CAFR accounts, when all these CAFR accounts from all the municipalities and the townships and all these counties and states is all added up, he's actually speaking publicly. He's like, on the public side, there's a deficit in the amount of, but he also goes on to say, after all the administrative process of the United States also puts in the bank $100 trillion a year. So he's kind of scratching his head. He's like, well, how can we have a surplus here and then we still have a debt here? Why? Because he doesn't actually understand the private side. He doesn't actually understand monies or proceeds or interest held in trust on the private side, accessible only by those who are entitled. And Walter just didn't quite, Walter hasn't seen enough of our videos to understand what's truly going on. But literally, you can literally watch this guy. He's an accountant, and he was tasked by the IRS or whoever in the United States to go through these CAFR accounts, and you can literally see him talking about it. And he's like, I'm one of the most world's renowned accountants, and he couldn't figure it out. So it's kind of cool that even though you're versed publicly, you don't know what's going on the private side. So just as a little substantive video there, if you wanted to check that out, it's pretty cool.
Can you spell his last name, please?
Burian, Burann, I think, or just a single N. And as a matter of fact,
Got it? Excellent.
Yeah.
Was
okay.
it 1 N or 2s? It had 2 N's.
Okay, so there you go. As a matter of fact, a good friend of Dean and mine back in Winnipeg was also a good friend of Walter Burian. So it was kind of neat how this, such a small world. But yeah, accounting isn't our job. It's not our duty. Even though you may love playing with numbers and all these credits and debits and stuff, I look at that as trustee work. I have better things to do personally than having to worry about all these numbers and all these accounts and all this stuff. Again, this is why there's an army of civil servants out there, and the ratio is almost 1-to-1. There's almost one civil servant out there for every man not working for the government, or woman. The numbers are very close to being 50-50 right now. So it's an incredible time to be assigned a personal representative to administrate all of your financial worries for the rest of your life based on the assignment and the delivery of a perfected security interest attached to a certificated security in registered form, and put that bad boy into possession of the successor in interest for his use. But the securities intermediaries are the ones who actually hold the thing. It's all fair. There's no collusion going on in the background now. So yeah, there you go.
So just to clarify the name of
Burien. Okay, there you go.
Walter, it's B-U-R-I-E-N, Burien.
Yeah, there you go.
Okay. Excellent. Okay, so you talked about the mortgage, you talked about the caveat, the declaration.
Yeah, the declaration is, it's similar to an affidavit. It's just saying, hey, on such and such a date, I declare that I did this and I did this for the purposes of and to the detriment of, and the liability does this, and the blah, 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 blah. I have that. Jody has one that's complete. That will be posted for phase 2, which is coming up after the blackout, I believe. I'll have to check with the coordinators on that, but
that's our next blackout.
Oh, okay. See?
That's why we're doing the first blackout for stage 1, just to get this done.
Yeah, don't ask me. I don't know. Yeah.
And then we're going to kind of stream it out to a little bit more, and then we'll move on to phase 2. The reason we did this strategically, before we had 5 forms, we actually had the mortgage and the declaration included in phase 1, but we actually just removed that because that's enough to get you to court with those 3 forms. It's enough to protect you from anything going in your arm, from anyone taking anything away from you, arresting you, anything along those lines. So you're protected in that sense. And then if you want to take it to the next level, then that's where we're going to have our phase 2, and it's going to be built a lot more as a learning process as well.
Yeah.
Okay.
So as Jeb was suggesting there earlier, yeah, there is an agreement here. They actually do accept our proposal, our security agreement. And now this is where I'm suggesting, hey, Your Honor, make sure that these guys accept it, get them to endorse it, get them to do that stuff right then and there in chambers. I believe there are a couple stories of people getting letters back from the ministers of finances around the world saying, oh yes, thank you for your such and such. So is that acceptance? Yeah, absolutely. Take that proof, walk into chambers and say, look, Your Honor, they've accepted it. Now I just need you to ratify this deal, or for you to decree it to be so. And once that's done, we're laughing. So yes, I'm agreeing with Kaz. Send that notice to the Minister of Finance saying, hey, look what we filed at the Personal Property Security Registry. And if you get silence back, that's a good thing. If you get a notice back, well, that's a good thing too. Again, it works for us both ways. So silence is in keeping with the equitable doctrines running, because publicly, equity should be silent. You shouldn't even hear equity, because if you're public. But if you're on the equity side, no, equity's chirping pretty loud and clear, which is why equity in the public speaks or has its doctrines or its jurisprudence conveyed in the negative. Equity is always talking in the negative, and that's specifically just to keep the public confused. Until you actually can get your head wrapped around all that stuff, you're actually really not even capable of managing your own affairs. So it's literally, we got to go through this test. We're being tested, and they're watching, depending on how we react to it. Yeah, we know the world's a dark, shitty place right now, but what are you doing? How are you reacting to it? Are you passing the test or not? So there you go.
So Zev, I just saw your hand up. I'm just going to answer a quick question here as far as John is concerned. You asked us how you can assist with any step or phase in our respective place or state with each paper and form. So again, what we're going to be doing is we've started groups. The platform that we've created within our actual website is equivalent of a Facebook. It's prepared for a university. That's how massive this platform is. So we have groups that we've started. If you don't see a group for your area, please let us know. We've got an Australian one though, for sure. We've got quite a few. Kim just puts them up, and then you can actually start groups within that and even start forums. So that one of your forums could be like the Australian documents. And then you can just upload all of them there, because that's what we do, is then we go into it and we can compile, we pick and choose, and then we fire it all back in our format so that it's nice and easy for everyone that is going through the system. So how can you help? Start the join the group, and then please start groups within that. Stay in contact with us. Kim is going to keep anyone that is interested in becoming a team lead or assisting with the translation or the change of legislation, all that kind of stuff. We're looking for, leaders to be able to step forward. So thank you for, first of all, offering that. But yes, that way you can, step in and help people and answer questions, because we are just getting swamped and overwhelmed to the point where we have to do blockouts just to be able to put our phones away and not get stuck into the vortex. So anytime any of you can step up, we're so grateful for that. But yes, please join the groups, start collaborating with us, keep in tabs with us. Any forms, please send to Kim as well through our divergence@gmail.com, because we compile them for all the different areas. So we're kind of doing it through our email, and we're also doing it through our website as well to make sure we don't miss anyone or anything.
So, and the team leaders or the equity hosts for your respective area, for now, we're going to try to set you guys up with the most knowledge and the most direction at the moment. And then this way your groups will literally be working with you directly. And if the groups get out of control, and like James is experiencing the deluge of communications, it does get to be profound. The volume does appear. So if we have to add assistance to a loved one like James here, where more team leads are brought in to help deal with the nature of your group. If you've got 2 people in your group, well, we probably don't need 5 team leaders. But if you got 500 people in your group, you might need 5 team leaders. And we are conscious of, actually, again, we were just mentioning, bringing our team leaders or the equity hosts up to a certain level where they have the most knowledge that's relevant at this moment in time moving forward. So again, we're trying to provide an environment where everyone is assisted. Everyone has a go-to person. Everyone has answers, not very far away. Again, this collaborative effort, this collection of minds it's going to turn out to be something that we all dreamed about 10, 15 years ago. And now it's literally happening right here. So, and
this is the reason why we're bringing together such great minds. And, thank you, Kaz, for offering to help us as well, because it's so much easier if we can use the great educated minds out there already, instead of training a newbie, to help us with this. It's too far of a stretch for them. Right. So that's why, we're kind of calling on you guys and hoping you can see what we're trying to do here and collaborate. So thank you to anyone that's willing to do that. So, Zev, we'll take your hand now, please.
Just a quick question. With the notification we're sending stuff to Attorney General and Finance Minister, as Kaz and I would sort of mention a bit yesterday on here, is it worthwhile notifying the Port Master as well to have that level of authority via the UPU to enforce it through that area as well, just as another base to cover?
Yeah, absolutely. I think there's this is the heavy duty part where, hey, if we're sending out notices, let's just send out a couple extra just to make sure. And if it turns out that they're not parties of interest, the judge will let us know. So we win either way. And I totally agree. I'd rather cover a few extra bases than come up short and look a little bit foolish to a judge. But again, the fact that we've gotten this far, we are never, ever going to be seen as being foolish or unresponsible or all that kind of stuff. As a matter of fact, again, I've said this many times, we are doing the most honorable thing a man or woman can do. And there's a lot at stake, literally. It would be mind-blowing to actually be able to encapsulate and put all this together as to what this really all is at the end of the day. And again, I remember one time I went searching for, how do I, it had to do with certificates of title. How do I acquire a certificate of title? I mean, back in my earlier days when I was trying to research this, and when I punched that into Google, one of the examples that literally popped up was how to apply for a certificate of title to eternal life. Wow. I literally fell off my chair. I was like, what the hell is that doing right in the first pop-up? Because that's exactly what I'm trying to do.
Give me some eternal life.
So yeah, again, so after the Chamber's hearing, this is essentially what's going on. There's going to be an entry into the minute book. An entry into the minute book is literally on the private side. That's the book of life. The public side is the book of death. We were all entered into the book of death, abandoned our shit, and then we never made it to the better book. That's what's going on with our processes right here. Again, the Bible scripture talks about, hey, go into that town or that city and find me 10 good men. Guy comes back. Well, I couldn't find any. Okay, we'll go find 6. Nope, couldn't find 6. Okay, go find 2. Nope, didn't find 2. Did you find 1? No. Okay, destroy the city. What is that actually talking about? They're actually talking about go check the records. Has anybody come forward and expressed an interest properly? Has anybody perfected an interest in their estate? Has anybody entered the book of life? If there's no one in this city that's entered the book of life, there's no value to this city. Erase it. Pretty profound stuff.
One more quick one for you too, guys. I don't know if you guys are aware, but some of the crew that I've worked with for the last year or so very closely, we've set up our own social media platform, very much like Facebook, but it's actually owned and run by we the people. So we've got no fact checkers, no censorship, none of that nonsense. I'll put it into the chat what it's called, but just as you guys are a bit more momentum worldwide, I'm just concerned that Facebook with that, no, that goes against our community standards, which is basically things like breathing tend to go against our community standards nowadays. I've been deleted off Facebook because I'll put it up in chat for you. It might be worth you guys setting up something on there as well, because it's run by working people and it works very much like Facebook. You can have groups and share messages and posts and get all the info out without any of the censorship or fact-checking nonsense.
And essentially, Zev, that's what the Divergence platform is actually providing. It is another Facebook. Although we have a Facebook page, that's not our website. I mean, we have our own Facebook, like you're mentioning. Why? Because we don't agree with their community standards. And as soon as we start posting truths and this, that, and the other, Facebook deletes it, throws us in jail. So I'm literally doing this with Facebook, and I'm taking as much energy from Facebook and I'm pushing it.
We're converting it over.
And we're pushing them and these users to our platform where, hey, you're not going to go to jail for speaking the truth. And our platform is actually going to give you something of tangible value. We're here to help you land your interests where you can no longer be seen as the debtor. Huge. I know for a fact, Facebook doesn't offer anything like that. So I would love for your group, like you're mentioning there, to be at some level, have a group set up that has your group name with the Divergence platform, because I would love nothing more than to have heavy hitters from every spectrum or every industry around the planet. Whether it's health and beauty products, whether it's meditation, whether it's common law and equity, whether it's what are we doing to stop the vid problem. I don't care. I would love all of these heavy hitters to essentially start coming under the Divergence platform, because we are the family that literally is going to take seats in God's kingdom to come. This is the restoration of the kingdom. Us coming forward and coming with clean hands. This is what scripture is actually talking about. It's this freaking moment in time right here. So I get hats off to all of us for not giving up and having the perseverance and the fortitude to make it as far as we have. Again, congratulations to all of you guys, because we know this was not a fun journey. It wasn't easy. No, not at all.
Well, I'll get your links out on the Speak So and some of the other platforms are on for you guys. Try and get some more collaboration happening there.
Because
out through the Speak So platform as well.
Because again, can you imagine like 100 of the world's top individuals in one place? Look at the traffic that's going to be going there. Look at our influence there now. I mean, this is something Dean and I dreamed about for 20 years. We just never really thought it was going to materialize. But we never gave up on this dream. And, Dean has his website or his platform that he's dealing with. He deals a lot with, building communities and building like-minded people, sharing these events and all that stuff. I'm all for that. I'm not suggesting that that's not what we're doing as well, but building a community, I didn't want it to sound like, we're building like a Hutterite colony or a Mennonite colony where just everyone comes and lives in one farm and we all milk cows together. No, that's not what I had envisioned. Our community is global. It's a state of mind. It's a state of being. It's in your heart. It's following in the footsteps of Christ, trying to love your neighbor, not serving sin and Caesar. That's where I'm trying to push our community. As a matter of fact, I don't even really like the word community, but you kind of get the gist of where we're going with that. And again, we've only been here for what, 4 or 5-ish weeks. And again, we're looking at the impact that we're having now. And this is just going to grow exponentially, where we are having, relatively nice successes with going to court and getting into chambers and people realizing on these security interests, and all this good stuff is finally starting to materialize for us. And yeah, wow, what a time to be here.
Excellent. John, we'll take a question from you here too, please. And then Josh, would you mind jumping on and talking about our app as well too, please?
Sure.
Real quick.
Awesome.
Okay, go, John.
G'day.
Hello.
I haven't had time to, tend to my beauty products this morning, Darren, but excuse the look. I just wanted to sort of clarify what's been said so far in my own head to get an understanding. So the way I understand this path that you've outlined is, from what I understand of our system here in this country, we are at birth. Pretty much our birth establishes a trust. Yep. So we are, I'm sure most of us on here would know that we have our, I think in the States it's known as the live birth record, and over here we call it the form of information of birth.
Okay.
So our birth certificate as such, which is printed on security paper, is exactly that. It's a certificate of a unit in your estate. And that's why you can purchase hundreds of them at a time, if you like.
Sure. Yep.
So you're suggesting that we basically are returning, for the use of a better word, the certificate aspect of our estate.
That's right.
So
yep.
we remain the beneficiary of our trust estate as it's created at the time of our birth.
Yep.
We are relinquishing or divesting to someone else the securitized paper aspect of that estate.
Yep.
Yeah.
Yep.
And basically just, I guess, live with the benefit of the estate trust thereafter.
Absolutely. That's exactly what's going on. The trust that happened at, the trust that happened at birth was the implied trust or the temporary trust. It's sitting there. It's going to kind of go on autopilot until we come back and say, hey, let me convert that implied trust or temporary trust into a permanent trust or an inter vivos trust or an express trust, a trust for the living. Now we've actually opened the door. So what does that trust look like? Well, here's our terms and conditions of the trust. Again, that's a lot of that meat and potatoes is encompassed in the security agreement. A lot of that could just literally be flipped and called an express trust. Now, once that security is perfected, this is what literally turns the system on. Why? Because you took that certificate, which is, like you said, it's just a unit share or a shareholder evidence, a particular instrument that shows something's existing. But when we come forward and we complete that thing and send it back to the issuer of it saying, hey, credit this security or this certificated security to my securities account, because that account is actually sitting with a zero balance. There's nothing in it. Now, keep in mind, in order to create the certificated security, the security account had to exist first. So here's the account. It spits out a certificate, and then it's put into your possession. That account is now empty. There's nothing in it. We redeposit or we reposit that security back in, but we made it better. We added our signature, which just means we accepted it, we agreed, and we came to transfer it. And I also attached some value. That value is like the opening deposit when you go to the bank to open a checking account. Here's my opening deposit. It's a certificated security and registered form with consideration attached, and kaboom.
It's inactive without it.
Yeah, it's literally inactive without it. Yeah.
Okay, a couple of things. One is there are pretty much standard forms in what we call here in New South Wales our land registry services, which deal with transfer of title, etc., or interest in title, possessory titles, etc.
Yep.
So with your website, are you suggesting that we can drop those forms in there for you to review and or comment on or extrapolate information from?
Yeah, absolutely. And as a matter of fact, we're going to take components of these forms and build better forms that we're after. So your transfer of title. You know, you're not going to need every single piece of that legislation, but you're going to need 3 or you're going to need 2. So take those 2, and now we're going to plunk that, or cut and paste that into our document that's specifically devised. And again, a devisee is another word for a settlor or a beneficiary or someone who's entitled to something coming down the pipe, because the devisee is creating a devise. So we're transferring by devise. I've devised this simple concept, and we don't need all those pages. So yeah, you go ahead and upload or send up some of these documents. We, the group leaders and myself and others, we'll take a look at all that stuff. We compile it. We use it to generate our working documents, and then we will spit back to you guys the actual forms that are, again, editable and drop down menus and all that stuff. So you can't put the wrong information in. The drop down menus that Kim is creating, it tells you it's either this or either this, pick one, and both are sufficient. But it's actually kind of helping people create an environment where they're actually going to be protected. We were very conscious of this, because we know how,
Sensitive.
yeah, we know how the cavalry shows up, and they all grab documents, and people just start mucking everything up, and then they complain later how it all went sideways. Well, you're in jail. And you're in jail. So, and then they go online and say, "Oh, Dean and Darren, you guys are on crack. You guys are just here to screw everyone over." It's like, well, no, you didn't provide an adverse claim. You didn't perfect your interest, and then you went and you tried to put a plea of abatement before the court. Well, the plea of abatement, the plea of abatement works when you've got clean hands. You actually don't even have the entitlement to put a plea of abatement before the judge if you haven't assigned that security interest to the new debtor. So there is a step 1, 2, 3, 4, 5 that's going on here. And again, so phase 1 gets us into a certain position, and phase 2 is for, hey, while you're at chambers, here, Your Honor, this is the nuts and bolts of what I'm trying to do.
And we do ask that you email it to us as well. So not only upload it, then send an email saying, hey, I just uploaded this to your group, so that we can then sync it into our other group, because we don't want anyone to be missed on this. So that's why we're kind of doubling up just a little bit to make sure.
Put in the chat your email address so we can so I can send those things to them.
Yeah.
You can put your email address in the chat. Last thing is,
I'll let you do that if you don't mind, hun.
Can I? I've got an example here. A few on this Zoom are aware of what I've done. I'm not going to mention any names. Zev, Brad. I at one point in time in the very recent past, I thought I'd take a shot, because I like to read, understand, then try things.
Yeah.
Right. So long story short, I sent through one of their own forms, this is the Reserve Bank of Australia, my birth certificate back for encashment.
Okay.
And all they required was an account. But the response I got was basically, look, you're missing some information on the back of your birth certificate. You need to fill in the blank, right?
Okay.
So I think at face value, they're worth about $10 million. So the lady was kind enough to say to me, look, you're missing some information, basically, and you need to approach it through either a merchant banker or a broker.
Okay.
So I have been searching ever since, and I'm talking about probably 6-8 months now, thereabouts. Otherwise, I was that step closer to pretty much cashing in a couple of them, let's say.
Sure.
Have you heard anything about this now?
Yeah. So who would ultimately, or who could ultimately be the clearinghouse or the authorized party that's going to actually put all this together for us? It's going to be the courthouse and a judge sitting in chambers. They're the ones that are going to accept monies paid into court. Hey, Your Honor, I'm showing up, I'm depositing this certificate of security with this interest attached and this valuable consideration attached. And all of this is attached to my securities account for my use and enjoyment. Your Honor, I need you to do what you do, and then you send an order, or you convey this interest to Treasury or the Reserve Bank or whichever financial institution you're trying to deal with, their Treasury. That way, it's coming from a judge. It's coming with perfection behind it. There's no room for interpretation. There's no, oops, I missed that one. the Treasury people would not have sent the judge back a letter saying, oh, you missed something, you might want to add a few particulars. No, the judge will literally fill all that in for us, which is why I'm such a proponent now of getting to a judge to get them to fill in the blanks. Because you know what? I'm tired of spending my life looking for blanks that may or may not even exist. We have accomplished enough. I'd rather get it to a judge and say, here, you deal with it from here on in, because I got shit to do. You know, we're tired of doing this. We've been doing this for 20 whatever years. So enough's enough.
That answer your question, John?
Thank you very much.
Yeah. I mean, that's what I would do for you, my friend. Yeah, get your information. You know, get it wrapped up in that special affidavit. Special affidavit in equity, like we were speaking to yesterday. The equitable titles and the equitable influences, it's dripping in everything we're doing now. So I mean, again, I love putting the word equity all over everything. However, the judge only needs to see it once or twice somewhere in all of your paperwork, and he knows, okay, it's implied that this is a trust. So we do have some saving graces there. But again, the judge will be able to answer all that stuff for us. Again, we're supposed to come to court with, hey, Your Honor, I have the following questions. I need answers. And one of the questions could be, I know you can't disclaim the trust, Your Honor, so I know you're going to pick this up and you're going to continue with it, correct? You're going to get all this done for me in the background, correct? You're going to appoint the receiver or the personal representative, correct? You know, ask him these questions, and you'll be surprised at the answers. They are so excited that we've gotten this far. How do I know this? Well, I shouldn't even really be telling this story, but I had 2 firsthand meetings with an individual who worked at a particular courthouse somewhere in Canada, where she was the manager of the 5 top judges in this particular province. I'm sitting at her kitchen table, and she proceeds to tell me that Dean and I have a fan club at the courthouse. They are so sick of the corruption. They are so sick of all the shit that goes on, but nobody had the wherewithal or the balls to step forward and finally do something about it. This woman goes on to tell me to do not stop what you guys are doing. You guys are very close, and we're all cheering for you.
And she have a file on them.
She also goes on to say that since we've been coming, they are bringing up specialist judges from the United States to help train our judges.
What?
For all the equitable stuff.
Why would they be doing that?
Yeah, for all the equity stuff coming down the pipe. Why? Because the United States has actually been more familiar with equity and its jurisprudence and its pleadings and all that stuff. They were actually farther ahead of us than in the curve, because no one in Canada has been doing it. There are more people in the States doing it. Therefore, they just, and again, I took all of this woman's information at face value. She was very careful not to mention names and not to, violate any security protocols, but she was just, an off the record comment suggesting for us to not stop and that we're very close. So again, that should relate to all of you, and it should be an encouraging, little segment there that keeps that fire lit under our asses to not give up. And we've never been more fired up than we are right now. Again, I spent 6 years trying to get a chancery court hearing. And then boom, we walked in, got 2 back-to-back done. Thanks, like it was nothing. And I was like,
wow.
Yeah, that was pretty cool.
Okay, so real quick here, just because we've talked about phase 1 a little bit, can you just recap about the mortgage, the caveat, and the declaration? Summarize real quick what those are, why it's important.
Yeah, okay. So the mortgage is really, it's another form of agreement. You're having a party with property, and then you're having a party that wants to use that property and pay for it. Well, once we spin this mortgage, or we declare our birth certificate, really is what this is. We're declaring that instrument to be a deed absolute, declared a mortgage in equity. Once it's a mortgage, now we can attach terms and conditions to this mortgage. What are the terms and conditions? Well, you're going to pay me this amount per month for this term, or this amount of years. Well, as the settlor setting it up for the beneficiary, we're actually creating a situation where it's in perpetuity. It's kind of forever. And this interest is assignable to your heirs, successors, and assigns. So the mortgage in equity is very important. It is considerably different than a mortgage on the common law side, but they're like, once it's a mortgage, it's always a mortgage. And now we just literally flip it, and now we foreclose on it. The foreclosing is, hey, Your Honor, they owe me a duty of obligation or performance, and under the terms and conditions of this mortgage, here's what the mortgagor expects. And here's what the mortgagee can expect. And they have to agree to it. Why? Because they started it. They created the mortgage. They gave us a certificate saying, here, you can redeem this whenever you like. So then they're just sitting there going, waiting for us to come back and express our interest property. And if you never do, you waived it. And after 3, 5, or 7 years, if no family member comes forth after your physical death and claimed your interest that you abandoned, it reverts back to the state. It goes right back into the consolidated revenue fund, and everyone's happy. And nothing really happened. So the mortgages are very important. I will go into some more of that, probably again in our blackout Zoom updates, because in the 4 days here, like I'm planning on kicking out probably another 25 hours worth of video content. We're just gonna let it rip.
Poor Kim, her face is dropped.
So that's what we're this is where the direction's going. The caveat, what does the caveat do? It's basically just a shield. The mortgage is naked. It's just kind of vulnerable. It's kind of sitting there. It's like, I hope I don't get attacked by the public. The caveat is like a steel box with a lock on it saying, hey, unless you got the key, you don't know what's in this box. You're not privy to it, and you will never be able to access it. So who has the key to get into the mortgage? Well, you give that key to the judge, probably give it to the attorney general because he's the administrator of your life estate on the private side. Again, the attorney general has a capacity called ex officio, which means he's not acting officially, publicly. He can act in his respective duties, but privately. Beautiful. So he, in conjunction with the Minister of Finance, are going to look after, administrate all of your needs, desires, anything that the trust requires. They're there to literally protect your trust. We show up to create the trust and then we walk away. They're there to protect it. So again, freeing us up to go do other stuff. The declaration is, again, it's just like an affidavit. We can probably even post here Jody's for an example here in a moment. And in a moment that would be a little bit later. But the declaration, again, like an affidavit, is just outlining a whole bunch of terms and conditions and expectations, if you will, and what happens if this happens, or what happens if that happens, and how, in good faith, it is expected that the receiver is going to manage the property of another with good conscience and good reason, that they're not going to be just, oh, look at that, someone expressed us a trust, I'm going to take all the dividends and I'm going to take all the proceeds for this for myself, and I'm going to go buy a yacht and a plane and an island. No, this is why the judges are there, to monitor all this stuff, to make sure no shady shit is going on in the background. Again, your judge is going to be your advocate. We've actually heard stories of the judge will come to you. If you go to vacation in Mexico and you get thrown in the can for smoking weed on the beach, you can literally call up, get a hold of your judge, and your judge would literally send a representative or an email, or the judge himself might even show up to come to your rescue. And here's another chunk of evidence for that. The Supreme Court in Canada was typically situated in Ottawa. That's where they've always sat or heard matters, in Ottawa, right? The capital of Canada. It's been that way for a while, since Canada was created. A summer or two ago, the Supreme Court of Canada actually moved to Manitoba, and they were actually holding hearings in Winnipeg. That had never happened before. So the judges in their circuit will move around. They'll literally come to you. And once your judge is your advocate, he's literally your friend. Hey, Jim, yeah, I need to do such and such and such and such. Yeah, okay, no problem. But you can't have that relationship if we don't have clean hands. And if we didn't get into chambers showing and providing and furnishing all these critical components with the paperwork. Yeah, you probably could go in and do it all verbally. I'm not even good enough to do that yet. And some people may have, but you know what? Yeah, I like doing the paperwork stuff. Why? Because I can post it online and show others how to do it and give them examples and give them the tools or the keys to better their lives. And it's kind of really cool how, we're always hearing stories about not throwing pearls to swine and not be putting this information out there for everybody to consume it, because they're all going to run off like hooligans and do stupid shit and get in trouble. You know what? From my experience, we are having a tough enough time getting to court and making a mess of this stuff by ourselves. I mean, we, with the most knowledge that we do, are going to be in a position where, hey, give back to those coming down the pipe. So that's why we're going dark, putting out another 20 or 30 hours worth of video content that's explaining well, what the adverse claim truly is. And in that description, like I was suggesting, I will do a nice little blurb on mortgages, well, probably several, where I'll be talking right from Gibson's book. I'll be quoting stuff from Pomeroy. If you really want to become a mortgage master, read John Norton Pomeroy. This guy was a chancellor from back in the day. This guy was a freaking wizard. These, between Henry Gibson, John Norton Pomeroy, and Joseph Story. Joseph Story back in, I think it was like the mid 1800s or late 1800s. This guy was like not even 30 years old. I think he was 29 years old or 30 years old. Supreme Court Justice of the United States. An equity master. He was one of these idiot savant guys that just knows it. And he goes on to create fundamentally a lot of the backbone or a lot of the jurisprudence that's been handed down over the years in all these, treaties on suits and equity and suits and chancery. These contributors, these three, if you want to get your head wrapped around equity, do not look outside that scope. Those three, all you really need. It'll blow your mind at Pomeroy's version of mortgages. Pomeroy was actually quoted, I think, in the mid or late 1950s. I think it was in a New York circuit court somewhere in the United States. And according to John Norton Pomeroy, blah, 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 blah. So this stuff is still very relevant, even though it's 100 years old or more. No. It still has all its effect, all of its ability to bring justice, the principles and jurisprudence. It's all sitting there for us. All we had to do, again, I keep saying, perfect that interest in that certificate and get rid of it. If you perfect the security interest and you maintain possession, you actually don't have control. This all boils down to the one of the two. We've had possession our whole lives, which is why we had no control. Oopsie doops. Give us our control back. You guys have possession. Watch how the world turns now. Different.
And you guys you mentioned you wanted to see the declaration. So Kim, I just gave you co-host ability. If you want to pop that up real quick for me. And we'll just give you a sneak little peek at this, okay?
It's a page long. And
I'm
again,
just looking for it.
Sure. So that one's about a page long. I whipped that one together really quick. So if there's a suggestion that comes down the pipe, again, we're always open to suggestions, and for us to add a little segment here or there based on, look what I found. I just had a friend that went to court yesterday and this is what the judge said. You know what? Again, we will always be willing to incorporate new technology or new direction or new, hey, look what we found.
And Kim, do you want to just go on some of those fields and just show people how it pops down and what we've kind of done here? Okay, so there's some fields where it's his, her, other. Okay. Guess we have to do that now.
Yeah.
But that on or about, so you can see where there's the date, you can enter that all in. So it's nice and easy. It makes it very simple.
Sure. So again, the chattel paper, that's actually what the birth certificate truly is. It's an instrument, but they actually really kind of classify it as being a chattel paper. Once that chattel paper is perfected and put into the possession of, like we're suggesting, this is what constitutes the trust. Once the trust is available, or once the trust arises, now the judge can say, I acknowledge your trust, and here's what I'm going to do to come to help you. That's all we've been fighting for the last 7 years, was to get the judge to recognize a trust. Now, don't get me wrong. I sent in lots of paperwork to lots of government departments that basically said, no, this isn't a valid trust. This isn't a valid trust. And we did a lot of head scratching over the course of 7 years, but it wasn't until we just recently came to understand, hey, you got to perfect that silly little security certificate and you got to put it in the possession of someone else. As soon as that happens, now you have a trust, because it cannot be presumed that you're liable because it's no longer in your back pocket. You're only liable because you're in possession of it. It's literally that simple.
Okay, so we'll take a question here from John again, please.
Okay. Darren, so can you just give us an update of where you're at in the process? Have you actually, I guess, completed your...
where I'm at. Yeah, I've done everything I've said I'm doing. I am just about to put the motion before court, just like Jody and our other friend Tamara here are about to do. Manitoba did not have the electronic version of submitting our documents to the personal property security registry. So I had to do it manually. And by doing it manually, they like to keep my stuff and then go quiet. They don't even get back to me anymore. So that tells me they've accepted it, because this happened 4 or 5 months ago. And then I got to the point where it's like, okay, we're safe because we know for a fact when there's a problem, that's when the government gets back to you. If there's no getting back to you, that means they're just going hands off and they're just going to wait to see what your next move is. Long story short, I had to come out to British Columbia here, and I met this lovely lady and another lovely friend of ours, and Kim's part of that list, of course. So because this province had an electronic version, we were able to get the output right away. We took that output, ran right to the court, and they went, yep, we'll entertain this. See, whereas I didn't have that. So I got to do a little bit more legwork to actually get caught up to where these guys are now, which is a little bit ironic, but that's where it is. So I do believe that once the process or the motion or the application and the petition are sent in, and as a matter of fact, I'm going to try to do it in this province rather than deal with it the province 1,500 kilometers away, just to prove to everybody that it can be done where you are. There's no need to go back to your place of birth or your country of origin or whatever that looks like. No. You can effectively deal with it wherever you are. So I'm going to guinea pig that one through just to prove it. And if I run into a roadblock or two, yeah, I'm all for reporting that. So just to keep everybody on the up and up.
And we've talked about this, John, before as well. Darren is a little bit strategic in staying back in the whole process. That's why he's using me and Tamara as guinea pigs, because he doesn't want to be gag ordered. He doesn't want to have a seal where he can't speak and teach us this, right?
The non-disclosure agreement. I would gladly relinquish or waive access to my estate to put everybody else through. Can you imagine? I go through and then I get strapped with a gag order and I can't even have these Zoom meetings anymore. I can't let that happen. So I will gladly never cash in on mine just to make sure everybody else does. People might look at that and be thinking, well, that's very honorable of you. But if it was me, no, I would cash in my estate. And I'm like, yeah, I know. It only takes one of us to not go through to teach everybody else. And I'm actually honored to be given that opportunity just in case it happens. If it doesn't happen and there are no do not disclose or do not disclose agreements, great. Then we're all fine. We're all laughing. But
we don't
that's okay. I'm happy to carry you, mate. No problem. That's okay.
Yeah. So that's something that I've just kind of put out there, and that's the way I'm running it.
My last question is: do you think at any point throughout this process in dealing with the court will come back and say, no, piss off?
No, not at all. The equitable doctrines were here before the common law. The common law came later. So it's only under common law that they could ever not play ball. So that's why we're actually bringing the equities in, and we're saying, hey, equity will not allow a trust to fail for want of trustee. It's not the common law saying that. The common law is saying we don't acknowledge trusts at all. So why would we even be dealing with that jurisdiction? Nope. Here, Your Honor, look at the equities. Again, all these chancellors and all this equitable jurisprudence came from the ecclesiastical ministers from thousands of years ago. So it was through the divinity of creation and scripture and all that awesome Roman civil jurisprudence. That's where all this comes from. And you know what? Dean and I firsthand, we've seen enough examples of this stuff working, even though we haven't cashed in on our estates yet, or even though we don't have access to our treasury accounts yet. I've driven through a check stop with a birth certificate, no driver's license, no registration, and we drove right through like it wasn't even there. So there are examples of this working. And at the end of the day, we just have to be diligent. Again, equity aids the vigilant, not those who slumber on their rights. So it's important that, because we've spent 10, 15 years to get this far, that we don't stop. But my direction here is, hey, I'll gladly sacrifice my own to put everybody, or, I'll gladly sacrifice myself to put the other 139,999 through, or 143,000. I didn't do very well in math, but So yeah, I mean, that's ultimately where we're heading. And again, to have individuals like yourselves and Jody here who have no problem walking into court and say, yes, Your Honor, although I've only been studying this for 3 months, I know enough. Look what I've done. Blah. This was meant to be simple. This was meant, and here's the other thing. I am convinced that that one particular little birth certificate that we're all carrying around is enough to effectuate or give credence to everything I'm talking about. Do you really got to go get your live birth record and get it authenticated and duly authenticated and send it here for this, that, and the other, all that stuff? I'm thinking not necessarily. Equities doctrines are basically saying this. As soon as you come to the realization, or as soon as you contemplate, hey, I finally just figured out what's the problem. Boom, I can get into court within 4 hours and deal with all this based on what I have in my pocket right now. So when we go and we search and do all that other stuff, all that other extracurricular events, is there value in that? Absolutely. I mean, there's all kinds of cool stuff going on there. Again, authenticating a certificate. Who can authenticate it? Well, only the owner can authenticate it. Therefore, you just admitted to being the owner. And if you're the owner, then don't you want all the liability to go with it? Wouldn't you rather bear the burden of liability? And they have to say, well, yeah, I guess so, because we created it.
Sorry,
I can see all of you guys thinking right now.
Sorry, go ahead.
I was going to add to that, Darren. There is case law here that actually states that you cannot split equity title from equitable title. Sorry, legal title from equitable title and hold them separately.
Yeah, I'm going to disagree with that entirely. The grantee is the position where both titles show up in the same person. Merger. Once that merger takes place, now the donor or the settlor gets rid of one of them. Legal title back to legal people, equitable title back to equitable man. Now, here's the cool thing. We've always had our equitable title. We never gave that away. The crown was never in possession of our equitable title because they never could be. Equitable title actually comes from creator. You actually can't grant that to a corporation. But what the corporations did was say, hey, I'll tell you what then, volunteer for this. We'll create a whole other title for you, and then we'll clothe you in that new title so that we can't see your equitable titles underneath. They're still there, but they just can't recognize it. They can't see it. They can't hear it. They can't act or adjudicate on it. Effectively, no good. That's the public system. That's the public realm. So we've always had the equitable. We just got to get rid of the legal title, literally get rid of it, because we have no business holding on to that one.
I don't think they want you taking your top.
Oh, yeah.
Oh, good stuff. Okay, so that's where the lawyer of skins under the Unit Title Act came in.
Yeah, absolutely.
Excellent, Kaz. Yeah,
for sure.
Wow. Any other questions? You guys look like you guys got a bunch of downloads over there.
Give her, my friend.
Just I've got to go shortly, guys, because I'm meant to be at a festival today.
Sure.
I've got to bail at like mid, which is like 10-15 minutes for us. Just want to put out a thank you and just stoked to see the collection of minds that have been pulled together today to be able to work through this, especially with so many of us here from Australia. Some very talented, knowledgeable people here, which is awesome to see. I'm looking forward to getting a bit of a group together for some of us here in Australia to help work with you guys and apply this to the Australian law and legislation. But like most of the guys on here from Australia, we've all been doing this for years. Most of us all know each other. So it's just awesome stuff. Thank you to you guys for bringing all these teams and people
together.
One big family.
Absolutely. Thank you, James, for that, for sure.
Yeah, thanks, James. Yeah, thanks for your comments, Zev. I mean, again, very few have dove into the common law more than Dean and I. And again, we appreciate everybody here and everybody's efforts. And again, congratulations and nothing but admiration and respect for all of you. And we're going to get there. Again, we're not going to stop. And it's all your hearts and minds that are helping us get out of bed every day to accomplish what we're here to do. And we're going to go down in history as being the ones who really, really, really came forward and established, again, that kingdom. So appreciate, Zev, everything you've done and everything that you're about to do, and the heart and the mind. The fact that you're out there helping as many people as you can, again, speaks to my heart, because that's truly what I'm here to do too. Again, I've never professed to have all the answers, but you know what? Someday we will.
Yeah, we will.
Yeah.
We're going to do a big drop for all of you guys. So we're super excited about that. We have our team, everyone's getting into place. We will kind of deal with our app that we're doing on another Zoom because it is quite early in its infancy. So
But
James
does Josh want to talk about that real quick?
no, he's going to talk about it on a different Zoom.
So I missed that memo. Sorry.
Yeah, and you just missed my hint there too. Okay, but yes, absolutely. We're working on a lot of exciting things. And again, so please understand why we're doing this blackout. And if you can join our groups and add to that in any way, again, we welcome you. Please send it to our Dîevergence. I did put in our Gmail account there. So please put us in your contacts so it's nice and easy for you to get a hold of us. Okay, James, is there anything else that you wanted to finish up or ask at all?
Yeah, definitely. I just want to thank everyone for coming again, but anyone who is willing to put some effort into the document side of things, definitely go to the Dîevergence website, 100% get on the Aussie group. We'll find, we'll make a form for step 1 or phase 1, adverse claim, affidavit, the rest of the security agreement. So anything that, so anyone who is well-versed in legislation and acts who's willing to put some effort in, jump on there and just go to town and just upload. And then you guys will obviously supervise it on the other end and then suck it out and
Yep. And ultimately that the only discrepancies that we're going to run into as well, New Zealand or Australia doesn't have number 49 like Canada does. So what should we put there in place? Well, okay. So once we get our team leaders here to a little bit higher level, I'll be the one that goes back and says, okay, if we don't have 49, let's use this one.
Yeah.
So yeah, I'll always be available to help plug in those little deficiencies. And you guys will be surprised. I mean, they're very cohesive between the Commonwealth. I mean, Manitoba or Canada's little version might be 49, but then Australia's is 51. Like they're not very far apart. The odd time you won't be able to find a particular one, but I'm going to suggest that's only going to happen the odd time. It's not like you're going to not be able to find 30% of what we're talking about. No. You might just miss 1 or 2 and that's it. And a lot of the times, because there's so much substance here, you could probably not even use those 1 or 2, and the judge is still going to be able to say, well, I totally see what you're trying to do here. And yes, I will acknowledge the trust and I will take over from here. So again, we're safe, and the team coming together and helping build documents, because this is going to spread. I mean, how many territories and provinces within the Commonwealth are there? Well, I'm going to throw it out there that there's probably thousands. So that's a lot of generations of our particular paperwork that we're doing, because ultimately at the end of the day, I would love to have this system available for every one of them within the Commonwealth, and then go to the other countries who are also using the birth certificate system and do it all for them. So really, somebody here has got a lot of work to do.
So if you're willing to help us, please put your email into the chat. We'll keep that private, of course, because we understand that we don't want a whole bunch of people bombarding you. So that's just for our personal information, because we do have a bit of a spreadsheet that we're keeping and cataloging for all the different areas, all the team leads. If you're helping with documents, that's wonderful. We do have a very elite Dîevergence Telegram group as well, which is all our team leaders, our IT people. And that's where we all kind of communicate, so that we're trying to delegate this to our equity, what do you call it? Equity hosts. And then they kind of disperse it down from there. Okay. Because right now we're dealing with everybody and it's just not working. We have to create some kind of a format of a flow down. And that's kind of where Anthony's going to be really helping us with that. So please put your emails in there. And thank you again so much, everybody. This was a wonderful privilege to be in front of you and to be able to share, Darren's knowledge with you. And if there's any way we can help you, please let us know. Kim, yes.
I'm transferring the email, so don't shut down this meeting, please.
No problem. So yes, we will be posting this up tonight. I will be putting it on our Facebook. If you don't have Facebook, don't worry, I put it on our page as well. If you don't follow me on our Dîevergence page, please do so. I post absolutely everything that I put on Facebook there. So that was including some of the authors that he brought up, as well as the books that he pulls from. So there's lots of good content on there for sure. And of course, even Zev and Kaz, yours is up there too.
Sure. And as I was mentioning earlier, like John Pomeroy there, for example, the guy's got more than one book. So you don't really need to get back to me and say, okay, Darren, which one of the 15 should I look at? Just pick one. It's fantastic. And once you start, you're like, oh my God. And the cool thing about reading these equity paragraphs are, take a moment to actually read these things slow and let that stuff sink in. I was never proficient, or I never really enjoyed reading when I was younger. And now I'm finding, well, as soon as you start reading these equitable jurisprudence manuals or books, literally just go at it a paragraph at a time. Make your notes, make your highlights, because they are so saturated with information. You can't just skim through this stuff and read through half of John Pomeroy's book in an hour and say, oh yeah, I get it. Yeah, no.
Oh, wow.
It doesn't work like that.
And oh my goodness, I just have to say thank you to all of you. I think every single one of you put your email address in there. So just like that outpouring of support is just so overwhelming for us. On some level, it must resonate. And this is what we're talking about, collaborating and paying it forward and just really stepping up for the world. You know, the world needs some heroes. So thank you for hearing the call. That's wonderful.
For sure.
We will count you among our loved ones. Our base is growing immensely, which is great. So, and there's a special thanks in here to Mark. Is it Mark? Sorry, all of a sudden you guys all just put in a whole bunch of messages. So 1 second here, I just got to find that. But yes, when you guys are offering to be able to help and assist, Mark, you said that you're prolific in document writing. So that's great. I might have to pair you up a little bit with Darren and kind of take some of his load off. So that's wonderful. So we did put up our website. It's dïevergence.com. It's in there. So that's wonderful. Thank you again, everybody. And we're hitting the 2-hour mark. So if there's any final comments or questions, please let us know. Otherwise, we will let you go. Kim, you got it, everything that you have there? Okay.
Awesome.
Excellent. We good? Have a great time, Zev, at your festival. Oh my goodness, a little jealous. You get some towns for us, okay? And you too, Aussies. Awesome. All right, you guys, take care. We'll talk to you soon.
Until next time.
Bye.
Love you guys.